Okay, we are going to get started. Happy holidays, everybody, and thanks for joining our webinar about the Colorado Equal Pay Transparency Law. This webinar is being recorded and will be sent out to all registrants. Everyone is going to be on mute, but as we go along, if you have any questions, please enter them into the chat and we'll get to as many questions at the end of the presentation. My name is Phil Roberts. I am the Senior Advertising Director at Bayard Advertising, and it is my pleasure to introduce David Fisher, who works at the employment law firm Davis and Gilbert. Welcome, David, and can you give an overview of yourself and your company?
Sure. Thanks for having me. So as Phil mentioned, my name is David Fisher. I'm counsel in the employment department at Davis and Gilbert. I've been with the firm for about 13 years now. We're a firm of about 130, 140 attorneys that provide, as you can see on the screen, a fairly broad spectrum of advice and assistance to our clients in a variety of areas. Obviously, my specialty is labor and employment, kind of helping clients through the changes in the law, such as the one we'll discuss today in Colorado, among others, and look forward to speaking, I guess, mostly to everyone during the webinar today.
Great. Thanks, David. And Bayard Advertising is the largest privately held recruitment advertising agency in the nation. As a full service recruitment marketing firm, our solutions include competitor candidate research, ad campaign design and execution. We have an award-winning creative branding staff. We provide in-depth reporting and analysis, as well as an RPO group to help engage with potential candidates. In 2023, Bayard celebrates 100 years in business. I've been with the company for over 20 years, and don't hold it against me, but I am located in Colorado. So, the Equal Pay Transparency Act was passed in November, and it goes into effect in about 2 weeks on January 1st. We pulled the key clauses from the law, and I highlighted the main verbiage. An employer must announce all promotion opportunities internally. An employer must disclose compensation range and benefits, and an employer must keep records of job descriptions and wage rate. For our purposes, we're going to focus on just the first two. So, David, just in these 2 sentences, there's a lot to unpack here. Can you give your overall interpretation of the law?
Sure. So for those of us who like to read the preamble to statutes, which I assume is no one but myself, the purpose of the law is kind of a continuation of an effort to combat pay disparity. So they talk about the fact that there's still a great disparity in the rate of pay for women as compared to men, and as well as for people of color. And so, you may be familiar that there have been certain attempts to combat that issue at a federal level, as well as in various states throughout the company, such as salary history bans in a variety of locations where you can no longer ask someone about their salary history when interviewing them or hiring them, because to the extent that they have historically been discriminated against, the salary that they come with might be because of past discrimination. And so the goal of these laws is to make it an even playing field, or the same pay for the same job. And so this is kind of the next evolution of that. First, part of this law, in addition to these posting requirements, is a salary history ban that's now going into effect in Colorado. But in addition, this kind of forces employers to say, this is how much we value this job at, or what we'll pay for this job. And so it attempts to eliminate some of the other factors that might have previously gone into distinctions or differences in pay for the same job responsibility or at the same job title, with a few exceptions that we may talk about as we get into the presentation.
So, David, one of the questions that I had was if the law was created to close the pay gap among gender, doesn't a salary range kind of diffuse the purpose of that law?
Well, I don't know that it entirely diffuses it. I think it's an acknowledgement that there may be legitimate bases upon which people in the same position might have somewhat different pay, right? That not everything is static. So someone might have more education or more experience, and along those lines, might be paid slightly more. And the law talks a bit about legitimate distinctions in pay, but the band or the range is consistent with some of the other equal pay measures that we've seen. For example, EEO reporting about pay ranges, right? An acknowledgement that we look that not every job is going to have the exact same salary. So we do want to make sure that it's in a reasonable range for that position.
Okay, sounds good. So, does the law pertain to just a company job rec, or does it affect their job postings on ZipRecruiter and other sites?
Sure. So it's going to apply everywhere, anywhere where the job is being posted that says we are hiring an account coordinator, we are hiring a cashier, whatever job we might be hiring for, that we are then required in that posting, whether it's on social media or on third-party sites or otherwise, to include in that posting the wage information, the benefits information that's outlined within the law. So there's no kind of exclusion for ads based upon or postings based upon where they are being placed.
That leads us into geographically, where does this apply? Is it only to jobs in Colorado?
Sure. So a covered employer is anyone with any employees in Colorado. So if you have one employee in Colorado, congratulations, you are now subject to the law. The law does contain certain geographic limitations around the posting of jobs externally, as well as the promotional posting internally. To the extent that the posting is going to occur solely outside of Colorado, this law would not apply to it, right? So if we're able to, use our technological capabilities to ensure that the advertisement for the job doesn't show up, isn't available to people in Colorado, the law wouldn't apply. If the job is to be performed entirely outside of Colorado, so you're going to have to show up to an office in New York or California. It's not something that you can do in Colorado as it relates to your external postings. The law would not apply to it, right? The law is obviously concerned about job opportunities for people in Colorado. Where that becomes an issue, particularly in the age of COVID, is that so much work is now being done remotely. It makes it much more difficult to say that a given job can only be performed outside of that state. So we need to think about that with respect to the external postings. With respect to the internal postings or the promotional opportunities, the assumption in the law is that essentially, if I'm in Colorado, potentially I could move somewhere else. So you don't have the same lack of requirement based upon where the job will be performed as you do elsewhere. However, what the law does say is that you're only required to provide this information to your Colorado employees. Again, Colorado only cares about its citizens. So you do not have the same promotional obligations or obligations to post potential promotions to employees in New York or California or elsewhere. You only have under the statute the obligation to report it to your Colorado employees and people.
So if I have a job out of Miami, if I have like an IT job, but it can be remote, do I have to take that into account when posting the job?
Yes, if it could be performed from Colorado and it will be advertised in Colorado, then the law will apply and the wage and benefits information will need to be included.
So if I post a job on a national website, but I choose Miami as my location, but somebody from Colorado could filter their search by Miami, I have to make sure that I'm compliant.
If it's a job that they could perform in Colorado, yes. If it's a job that we can establish can only be performed in Miami because let's say that's where the servers are and we need you to be on the ground in case of emergency or the like, then I think you'd have an argument that the law might not apply because it can only be performed outside the state. But again, that's where we have to analyze, in today's day and age, what can only be performed, feet on the ground in that location versus what can be performed remotely.
I think that's an important differentiation to think about. In terms of advertising, I understand that salary range benefits must be included in job postings, job recs. But what if we want to run a general banner ad on Facebook or a Google display ad that's generally saying that we're hiring? Do we have to follow the law for those types of advertising?
Not as I read it, because you're not really engaged in a job posting in that banner ad. That's just saying we have jobs available. Click here to learn more, right? And then the landing page where you actually list the positions that you're hiring for is where this law would then become applicable as it relates to the wages and the benefits with respect to those positions. But if it's just a general, hey, would you like to come work for us? Click here. I don't think the law would apply to that as I read it.
Okay, so if we create a landing page that is compliant with the law and we run branding ads, we're going to be okay.
Yeah.
Okay. How about internships? Does specifically for unpaid internships, do we have to comply with the law there?
Well, that's an interesting question. Unpaid internships it's rare that they are compliant with law. Generally, intern is a job title. So if we are, paying our interns, which in most instances we're going to need to do or should be doing,
Right.
call me if you're not, that's an employment opportunity that you're posting and putting externally, and there's nothing in the law that would exclude internships from this requirement. If it's a truly unpaid internship, and those are usually going to be for charitable organizations or volunteer activities, is where those are or educational opportunities. I think you have an argument that it's not an employee because you're not suffering or permit them to work. It's something different, right? It's an educational environment. So I think you'd at least have an argument that as it relates to unpaid internships. Also, wages and benefits would be kind of irrelevant there because there are none, right? If they're unpaid interns, there's no wage or benefit information to put into the post anyway.
Gotcha. Let's talk about for sales roles. Do we need to include the specific commission bonus structure for sales positions? That structure can change quarterly, even monthly. Will a generic statement about a bonus structure be sufficient?
They say there needs to be a general description. So I don't think we need to get into the granular details of the quota is going to be X, and if you hit it, you get Y%, and above it there's an accelerator. I don't think we need to get into that kind of detail, but I think we would need to provide more than just you will be eligible for bonuses and commissions. I think if there's a commission program, something like between 5 and 10% for for revenue from new clients brought in, or something along those lines, something descriptive as to what the commission program generally kind of looks like, but we don't need to get into the granular detail of exactly how it's going to work.
Okay, terrific. How granular do we need to get for insurance benefits? Does it have to be, we offer health and dental and short-term disability and life insurance, or can we say we offer a comprehensive benefits package?
Yeah, more the former than the latter, unfortunately. It again talks about a general description of the benefits, and then it lists out the type of benefits that you would describe: health benefits, retirement benefits, paid time off. So we are going to need to provide more than just we offer benefits. We will need to provide some general description of what that looks like. Similar to commissions, I don't think we need to get into the granular of currently we pay 70%, the employee pays 30%. I think that's beyond what the law would require, but some general description of we offer health, vision, dental, et cetera, should be in there, with at least some specificity as to what the insurance programs are.
Since this goes into effect on January 1st, if I have job postings that I listed on December 30th or next week, is there any type of grace period? Or do I need to take down my posting, revise my posting?
Yeah, and unfortunately, there's no, grandfathered in. If we get a bunch of, advertisements or job postings out in the next couple of weeks, but we haven't yet hired for that position, a job posting is it's new every day as long as you're still looking. So as of Jan 1, those would need to come down and then be revised to be compliant. The grace period is kind of now, right? It's between when they actually pass the law and when it goes into effect January 1. This is the period and the opportunity for employers to, get themselves ready and get their job postings ready to comply as of January 1st.
And what great timing with the holidays coming up. What does announce, post, or otherwise make known promotion opportunities mean for us?
Sure. So if you have, a position that you're going to be hiring for, that you're going to be moving someone into, if it would be higher in wage or or reputation or title for an employee that you have in Colorado, there's an obligation before you make any sort of decision that you announce it to, the individuals in Colorado that there is this opportunity. Tell them what the job is, what the wage and benefits are, and how they can apply. There are some exceptions to that. One of them is, let's say the person who's currently in the role doesn't know they're getting let go yet. There would not be the obligation to publicize internally that that role is about to be open if there is that compelling need for confidentiality. Another exception would be if, let's say, someone's going out on parental leave, and so you're just filling the role for 3 months until they get back. You would not be required internally to let everyone know that that role is becoming open, because it's not really becoming open, right? We're only looking to fill it for a few months. If at some point any sort of temp position like that would convert to permanent and we learn of that, we then, have that obligation to let people know internally that it is becoming available. So we would then revert back to, gotta let everybody know.
Okay, so if if a position is going to be filled that's currently, that if someone is going to be let go, do we need to take any steps to protect ourselves in that situation?
Well, like I said, the law, as it relates to the promotional opportunity, does not require you to announce to everybody, and again, it's everybody in Colorado, that that position is going to become available. But if you're looking for someone to fill the role, you're advertising somewhere. So one of the questions becomes, if we're not letting people know that this role is available because someone's currently in it, so we don't want them to know, hey, in a couple of weeks you'll be let go, how is it that we are attempting to find the replacement for that person? And I think that's where we just need to be careful about, what are we doing to fill the role, and is what we're doing going to implicate this law potentially, let's say, with our external postings. But the law recognizes that we're not always going to be in this perfect world of, you let someone go, the position is open, and then you have the opportunity to try to find somebody. I mean, the real world is you typically want to know who's going to fill that seat first before you let someone go, because even if it's, let's say, a performance termination, the number of times it's, yeah, they're not great at their job, but I need someone in that seat. I need someone to still be working, so they might not necessarily know about it. And then if you're just talking about protection generally, outside the statute, obviously going through your typical analysis with respect to any termination about, are there any potential legal claims for the individual who's being let go?
You had mentioned that you must disclose to promotion opportunities to people in Colorado. It's probably best practice to announce promotion opportunities company-wide. Is that correct?
Yeah, I think it's also just probably going to be easier. I think most companies are unlikely to send like blast emails to people that, hey, there's this job open. I think the easiest way to comply is going to be probably an intranet site with, available positions or jobs that gets posted to, that I would imagine everyone's going to have access to. We have to be careful there if we have people who don't have access to the internet site. Let's say they don't regularly work on a computer. You have to figure out another way to let them know. Maybe it's a bulletin board in a cafeteria or something like that. But I'm guessing that's typically going to be how employers comply. And so I think the fact is that, everyone throughout the company is going to start to learn about, the job openings and the promotion opportunities, which isn't a bad thing. You may find out that you have people who are really looking to advance and who are very committed to the company. This could be a way to learn that information.
Great. So how does this law apply to companies that are using staffing agencies or RPOs?
Yeah, I mean, if you're using a staffing agency, there's nothing in the law that says that it no longer applies to you because a third party is going to go find the employee for you. So, as with most kind of vendor agreements, what becomes important then is allocating responsibility. So, who is going to be responsible for ensuring that when there's advertisement for the position, that it complies with, or when the posting is put up by the staffing agency, that it complies with the law. And then your indemnification provisions, right? That in the event that the staffing agency doesn't comply in the manner in which, they recruit for you, that you are protected as the ultimate employer, from potential actions by candidates or employees alleging violation of the law.
Yeah. I mentioned Bayard has an RPO division. We've already been following similar employment rules in California and Philadelphia, and we have been applying it to sourcing projects in all areas. But at the end of the day, it's up to companies to make sure that their staffing agency or RPO is fully compliant. So, what are the repercussions to companies if they don't follow the rules?
Sure. So there's some monetary liability. The statute provides that there can be a fine of not less than $500 and not more than $10,000 per violation. Each job that you're posting for would be one violation. So one thing that the law does do is, let's say you have a job that you're advertising across 9 platforms, but it's the same job. That's one posting. That's one violation under the law. So there's the monetary component. And then in addition, to the extent that you haven't complied, you haven't kept the records, if someone does sue for pay discrimination, there will be a presumption that any information that would have been on your compliant postings and in your compliant records, that it would have been bad for you. Essentially, there's a presumption that it would have hurt you in that lawsuit if you fail to comply with these obligations.
That's a pretty wide range, $500 to $10,000. Do you have any insight into what the determining factors are for the penalty?
Sure. So the law doesn't say. The law just kind of gives this broad discretionary power to the Department of Labor and Employment, who's going to enforce it in Colorado, to kind of determine what they think is appropriate. Given experience with other laws that have these types of ranges, the factors that you'll generally see them look at are, is this a one-time violation? Is this the first time? Or is this a company that's been dinged before? if there's been a pattern and practice of violation, you tend to get higher penalties. They'll also look oftentimes at the size of the employer. If it's a smaller employer, maybe a little less sophisticated, there can tend to be a little bit more mercy shown with respect to the fine than if it's, a larger, more sophisticated organization that they would expect should know better. So all of that can go into it. Additionally, what I have found is how you deal with the investigator who's looking into it can have a huge effect on how merciful to they'll be when deciding what that fine should be. Were you overly cooperative? Did you provide them the information that they were looking for? That tends to curry favor with with the agency, as opposed to you were combative, wouldn't provide information, wouldn't respond to phone calls. So it's also, there's a bit of art in how you deal with the agency that can often have benefits when they're, doling out the ultimate fine, as authorized under the statute.
You had mentioned investigator and lawsuit. Who is doing the investigating and who would file a suit?
Sure. So the Colorado Department of Labor and Employment enforces the law, and employees and applicants can file claims or complaints with the DLA about violations, right? To bring it to their attention, at which point, they would likely investigate and send a letter to, the company that's alleged to have violated the law saying, here's the information that we want. We want to see if you're in compliance. The lawsuit is not really going to be related typically to failure to post. That's going to be more the monetary fine or the penalty, and typically going to be done by the regulatory agency. But employees and applicants can sue under the law. Their lawsuit is likely going to be that they were not paid as much, or that they were somehow harmed. And that's kind of where they'll look at the other part of the Pay Equity Act, right? I didn't get hired, or I wouldn't take the job because it's a lower salary than it should be, and I didn't know the salary. And then what they'll do is point to a failure to comply with the posting obligation as evidence that, hey, this is a company that doesn't follow the law, that's non-compliant. And that's where I spoke about earlier, that presumption against you, that had you complied, the information would have been bad for you. Right. So that's the lawsuit's generally going to be about, I didn't get hired or something along those lines from the employee. The regulatory agency is going to be the one doling out the, under typical circumstances, the 500 to 10,000, after its investigation.
It seems like there's a lot of interpretation to these laws. It seems a little vague. Do you think that in the coming months, the law will be more detailed?
Yeah, I mean, in addition to the statute, there are some rules that were authorized and recently passed that provide a bit more clarity. But most of the clarity, and hopefully we're not the test cases for it, will come as enforcement actions occur. And so as you start to see how the agency is going to handle these things, the interpretations that they're going to take, to the extent that any of this gets into court, obviously case law on the statute will then inform how it's being interpreted and how it's being viewed by the regulatory agencies as well as by the courts. One other thing that I'll mention, just because there's some literature out there, is there are some business groups that may look to challenge the constitutionality of the law. I am not a constitutional law scholar, but I have seen some rumblings about that. So obviously, if there is a challenge, that could have an effect on whether the law goes into effect. We saw that a few years ago when the Obama administration tried to raise the minimum salary floor for exempt employees under the federal law. Judge in Texas stated it ultimately, didn't go through. You could see similar challenges like that to the Colorado law, although as of today, I'm not aware of anything having been filed.
Okay, great. Thanks for your insights, David. We had a number of questions come in. First question comes from Anne regarding the landing page. If there is a branding ad, then it drives to an informational landing page. But in order to view the actual posting, you have to click off the landing page to the ATS. Would there need to be salary info on the landing page where we're driving candidates to?
I guess it depends on what the landing page is going to look like. I'd probably want to see it, but if the landing page is a matter of you click, it lists the job title and then you click on the job title to show you the required information to be posted, I think that should be fine. I mean, the law doesn't say that you can't require them to take, a step to get to the information. But again, that's one of those things where, enforcement action may start to better define for us everywhere that it needs to apply. But, again, if it's just click on the title for the job that you're interested in, and when you get to the next page where you would apply, it provides you with all of the relevant information. By my reading of the law, that should be okay.
Okay, so it's up to a company's marketing department or recruitment marketing agency to make sure that they are compliant as it pertains to a landing page.
Yep.
Julie asks, does that have to be in the posting itself, or can we link to our page that already overviews that? And I'm guessing she's talking about benefits, listing the compensation.
Again, it's an interesting question, and we'll get better defined and better answers as we move forward. You're probably okay if you're listing it and then it's linking, by one click, you then get to the information that you're required to provide to the applicant. The more detail that you provide on that page where you're not giving the wage information and the benefits information, I think the more trouble you could potentially get into, because it's gonna look like a more fulsome job posting that doesn't contain the required information. So again, I guess it just depends on the level of specificity and exactly what that initial page has on it, and whether or not it is a job posting that now obligates us to comply with the law.
Along the same lines, Tracy asks, just posting the position internally will be sufficient. Yes.
So I assume this is
as long as it complies.
Yeah, I assume this is with our promotional opportunities for our internal employees. Yes, as long as the employees have ready access and know where to look, yeah, that's fine. You can post it on an intranet site internally.
Okay. Lewis asks, what about other states? We've heard rumblings that other states may follow suit.
It's entirely possible. We've definitely seen a lot of action taken with respect to pay equity. And what we have found is that once one state does something, all of the other states look to comply, and particularly among the blue states. So there's been this kind of ongoing race, for example, between New York and California to see who can provide more employee protections and employee benefits. And they seem to pass new laws every 6 months. Colorado's obviously getting into the game now. It would not surprise me if some of those other jurisdictions, follow suit so that they are deemed to be as protective of employees, and as protective of candidates as the other states. So it's certainly possible.
So to protect themselves in anticipation of expanding to other states, we should just be prepared to include compensation range and benefits in all postings.
Yeah, it's not a bad idea. It also will just take some of the stress out of making sure that we're posting, but we can't post this job in Colorado because it doesn't have the right information. So let's make sure that no one in Colorado can see it. Some of the stress of that is taken out of it if you just kind of comply universally. But obviously, companies will have to make that decision on a case by case basis for what they think is in their best interests.
Mike asked, our salary ranges are generally broad. Considering that fully remote positions would fall under this scope, this adds many geographic differentials, which further broadens the ranges. Is there advice on the best way to handle that?
Well, there's nothing in the law that says how broad your range is allowed to be. So if that is the range that people in that position will be hired at, and that's, and that's dependent upon where people are located, then that's the range that we put into the advertisement. Obviously, one of the things to then think about is that the candidates who come in who are in the areas where they're on the lower end is explaining to them why it is that they're on the lower end of the range that's in the advertisement.
Another question came in. Can you review your recommendations for including bonuses in job postings?
Sure. So I guess you have to provide a general description of the bonus. If you have the typical discretionary bonus plan where we kind of at the end of the year decide what we feel like giving out and you'll get something, then I think it's easy enough to say, discretionary bonus. To the extent that there are things like target bonuses or a bonus pool that's created, I think you will need to provide at least some information about, you'll be eligible for a bonus between 30 and 50% of base, something along those lines. Again, it doesn't need to get into granular detail, but you have to just provide them with enough information to understand what it is that they might be eligible for.
Okay. Jonathan asks if a company doesn't have an internal career site, will the external career page be compliant if our employees know that is where to look for promotional opportunities?
Yeah, I don't think you necessarily need to create something new for them if you make it very clear where they can look and that they have ready access to it. That should be fine. There's nothing in the law that says that the promotions need to be, in a different place. You could certainly have them all in one spot where it's both publicly and, internally viewable.
Okay, terrific. That looks like all of the questions. David, thanks for being on and providing clarity and your insights into what we are facing. Before we wrap up, any final thoughts?
Sure. So thanks for having me. It's been a pleasure. Obviously, it's always good for the employment lawyers when states decide to make life more difficult for employers. Obviously, my email address is on the slide and in the deck in case anyone has any follow-up questions. Also, this is one of many changes going into effect in 2021. California's updated its Family Rights Act. Colorado's minimum exempt salary threshold is going up to $40,500 and of course 20 cents because you have to add that on. And there are a number of other changes really in states throughout the country. We'll actually be hosting a webinar at D&G on February 3rd that's going to discuss a lot of that. So if anyone, would be interested or want to join that, shoot me an email, let me know, and I'll make sure the bouncer has your name on the list and lets you in.
Great. If anybody has any additional questions or would like ideas on how to make sure your job postings and your landing page are compliant, please reach out to us to go over solutions. And thank you for being on. We hope you have a safe, happy holidays.
Take care, everybody.